Thank you so much. And I see that the prime sponsor is here, Senator Hasegawa. The floor is yours.
Chair Nguyen, good to see you sitting in the center there, and Ranking Member McEwen and members of the committee, thanks for putting this bill on for a hearing. I very much appreciate it because it's a crucial topic that we need to get ahead of. Well, we're already behind, actually. To answer Senator Wellman's question, ADS it could be pretty broad. I mean, it's how you view it, but you know the old adage, garbage in, garbage out. That's like the programmer's mantra, right? And a lot of the problem with automated decision systems is the data set that they choose to input into the decision program. So maybe it is, maybe it isn't, but there is, as the bill that you heard states, they should be prioritized. If it's a very low priority thing, don't worry about it. But you know, they should assess each ADS system by their level of risk to consumers and the people as to whether it possibly jeopardizes their ability to get a job or their ability to get LNI or whatever it is. ADS are these very complex systems that take data from other complex, less complex systems, and so on and so forth down the chain. And each step of that chain actually should be analyzed. It could be a cursory analysis, just to say, you know, are we collecting the right data? Are we inputting the right information? Are we asking the right questions? So I hope that answers your question. It may be, it may not be. It depends. I sound like a lawyer now, don't I? So at any rate, I'd like to, there's going to be expert testimony that know a lot more about this stuff. I just want to talk to you a little bit about why I think it's so important. And I have negotiated with the governor's office till the cows come home, trying to get something that works for them. The bill that you see before you is not what we most recently proposed to the governor's office. If you, the committee, don't choose to move this forward, because I didn't make the proposals public as a proposed substitute without the governor's office's agreement, we'll just go back to where we started from and keep trying to build a larger movement. You know, but I think that there's close to 800 people signed up in support of this bill in the CSI. So my personal history is I've been a media justice activist since, let me put it this way, and Senator Wellman, you might appreciate this because I actually was on a waiting list for the very first Macintosh when they were first produced in 1984. And I learned programming prior to that. So actually the Macintosh was an organizer's dream. But that was a precursor, and the big commercial was 1984, right? Well, we may have created a 1984 rather than smashed it by, the democracy aspect is great, but when knowledge surpasses wisdom, we lose control over how that knowledge is being used. And that's what we're trying to do, is get ahead of it and invoke some wisdom into this process. So the history of this bill goes back to the 2021 session. We had an ADS bill back then. It was pretty aspirational, but we felt like it really encompassed what we need to do to get our hands around this ADS problem. The bill did not pass after much negotiation and back and forth, but we got a budget proviso for the governor's office to put together a task force or a working group. That working group actually came up with a consensus product, and it's this thing. It was headed by WATEC. And it's called Automated Decision-Making Systems Workgroup Report. So last year, we incorporated their recommendations that were consensus recommendations into a bill. that bill went nowhere after so much back and forth. I mean, I think we wore out poor staff to going back and forth trying to redraft and redraft. That ended up as a budget proviso, again, for the governor to at least do an inventory, ask his agencies to do an inventory and see what they have. So the result of that inventory was very dismal. Most agencies did not even respond to the governor's directive to do an inventory. So that's why we felt that this year we actually need to put it as law in statute, so maybe they will pay attention and at least do an inventory. So we ended up with the bill that you have in front of you that has a very scaled back version of what the recommendations were, but that was unacceptable to the governor's office as well. So we went and negotiated back and forth, back and forth. The final version is so scaled back that it's merely a shell of the original bill. All it does is incorporate the governor's office's recommendations, actually, and put everything else into an intent section so that it is not law, to sort of create a pathway on how we're going to deal with this once the inventory is done. I haven't heard back from the governor's office, so I presume they don't approve of that as well. So if that is the case, that's why I did not put this forward as a proposed substitute. One of the things that you might be aware of is that this actually has acknowledgement from the White House, of all places. So the White House Office of, what is it? I got the name of it here. White House Office of Science and Technology Policy, or OSTP. They actually produced this document, which is a blueprint for an AI Bill of Rights. And contained within it are numerous citations and scholarly studies about how ADS impacts everything from decisions on who gets hired to just the healthcare coverage, who gets it, who doesn't qualify in the criminal justice system. Let me find that piece of paper. I have too much stuff kicking around. I'm sorry, I'm getting everything's all mixed up. Well, at any rate, they offer numerous suggestions on how they offer the roadmap, a blueprint for AI Bill of Rights and how to build something like that to protect the people. So I'm hoping that you will accept the bill, first off, and let us keep working on it. But if you don't, well, I won't even go there. We'll just try and keep working on it and see if we can improve it so that it becomes acceptable for this. As I said, we need to get ahead of this program, and I think we're already too late. You know, our freedoms and our liberties and the way that decisions are being made are constantly threatened in ways that we don't even know and understand. So we need to understand it and throw some wisdom into this whole process. So I appreciate your support.
Thank you so much, Senator Hasegawa. Senator Banky has a question.
Thank you, Mr. Chair. Thank you, Senator Hasegawa, for bringing this forward. As you know, we went through facial recognition, privacy the last several years here at the Capitol. The one section on the algorithmic accountability, are you seeing that? I kind of triggered when you said the AI Bill of Rights. Are you envisioning this looking at the review board, using those Bill of Rights kind of as a framework to move forward for the state? And you've seen that in some of the products.
That would be the ideal.
Can you speak to that? Okay.
Moving that direction. We need to have accountability. We need to know what we're dealing with at least.
Thank you so much. Any other questions? Seeing none, thank you so much, Senator Hasegawa.
Thank you, Mr. Chair. I really appreciate your giving this bill a hearing.
Yeah, no, thank you for coming. And then for the first group, we'll bring up a panel of 4 folks: Ben Winters, Ann Paxton, Maria Angel, and Jennifer Lee. I might have said Miss Angel's name wrong. The characters are weird when you download it. Jennifer, since you're here, go ahead and get started.
Sure. Good morning, Chair Wynn, Ranking Member McEwen, and members of the committee. My name is Jennifer Lee, and I lead the tech policy work at the ACLU of Washington. I was also a member of the Washington State Automated Decision-Making Systems Work Group in 2021. We strongly support SB 5356 as a first step in creating transparency around automated decision systems that can be error-prone and discriminatory. Here in Washington and across the country, government agencies are increasingly using automated decision systems to make critical and even life or death decisions about people's lives. These tools can include public benefits algorithms that can approve or disqualify individuals for food assistance, and predictive policing algorithms that can use racially biased crime data to predict where crime will occur in the future. It is deeply concerning that these automated decision systems are being deployed without public notice or oversight. This lack of transparency means that people in Washington state often don't even know if these tools are being used at all and are not always able to seek recourse when these tools discriminate or violate their rights. The bill recognizes that there are many automated decision systems and requires that agencies create a framework for prioritizing examination of the systems based on factors such as whether the system has significant effects on people, affects many people, involves a high risk of error or bias, its level of transparency, and whether it has been independently tested for bias or accuracy. SB 5356 follows the consensus recommendations of the ADS work group and would create much needed basic transparency and fairness standards for government use of automated decision systems. We urge you to support this bill. Thank you.
Thank you so much. And then anybody, or Ben, feel free to go next.
Hi, thanks, Chair Wynn, Vice Chair Loveland, and members of the committee. Thank you for allowing me to testify today in strong support of Senate Bill 5356. I'm Ben Winters, Senior Counsel at the Electronic Privacy Information Center, where I lead our AI and Human Rights project. So automated decision-making tools are used to set bail, and similar ones are used to allocate law enforcement resources, determine benefit eligibility, public housing eligibility, what social services children in need may receive, and more. These tools are given a deference and an air of objectivity, but bias and discrimination are reflected in tools based on the data the algorithm is learning from and the systems the tools are used within. At present, there's no accountability for their impact nor transparency around their developer or the human and fiscal cost they cause. Since the past year or 2 years that this bill was introduced, as Senator Hasegawa mentioned, the White House published the Blueprint for Bill of Rights, and the National Institute of Standards and Technology released a risk management framework. Within both of these, the consultation with the citizens, transparency, testing, oversight, and heightened consideration based on the risk of the context they're used are all reflected. I just want to keep this short and simple. This bill does align with all of these principles and is not overly burdensome, especially after the past few years. It's been pared down, requires government agencies to disclose simple facts about tools funded by taxpayers. So Washington has an opportunity to innovate in accountability and transparency. And one other thing I wanted to just flag for y'all is that in California and Colorado and several jurisdictions around the world, requirements of audits and impact assessments are coming for both the commercial sector and the public sector. And so it would be best for Washington to get ahead of it. And so as is, the bill would be a huge step toward allowing Washington state to be that leader in adopting automated tools more responsibly. And I'm available and happy to answer any questions.
Perfect.
Thanks.
Thank you so much, Ben. And if you'd like to go next.
Thank you. Good morning, Chair Nguyen and committee members. I'm Ann Paxton, Policy Director of the Unemployment Law Project, and in support of SB 5356 and transparency about automated decision systems. In information technology, a black box is an algorithmic system with mechanics that its creators can't or won't explain. The use of automated decision systems in unemployment benefit applications has given us particularly striking examples of the dangers and fatal flaws of black boxes. In Michigan, an automated system known as MIDAS, starting in 2013, falsely accused 40,000 people who had received unemployment benefits of fraud. It demanded that they repay all the benefits back plus penalties and threatened garnishment, seizure of property, and prosecution. This occurred because automated decision-making screened claimants' files for alleged flags of fraud and sent notices requiring a response in 10 days. But many claimants never got the notices. They had stopped filing for benefits and were no longer checking their online portal. or they thought it no longer applied to them, or they had moved. They didn't respond, and that checked a box, triggering charges of fraud that ruined many people's careers and lives, all without providing them an explanation. We have the same unemployment IT vendor that Michigan had, Vast Enterprises, and something similar happened here. After providing benefits to support hundreds of thousands of unemployed workers during the pandemic, our IT system sent out questionnaires that many people did not return for the same reasons. With automated decision systems, missing the deadline was all that was needed to slam them with an overpayment notice, aggressive collections, threats of garnishment and seizure, no human review, and most claimants had no idea why the money was being demanded back. More than 100,000 of these cases occurred, and our agency is trying to repair the damages now. Black boxes are the enemy of equity. Only transparency can expose these harmful uses of algorithms and halt faulty automated decision-making before it strikes again. SB 5356 is an essential component of accountability for the protection and benefit of all workers and families of our state, and we urge your support. Thank you.
Thank you so much. And then Maria.
Thank you. Good morning, Chairwoman and members of the committee. My name is Maria Angel. I'm a fourth-year PhD candidate at the University of Washington School of Law and a former member of the Washington State Automated Decision-Making Systems Workgroup. I contributed to drafting the ADS Workgroup report, which was approved by the Governor's Office. I strongly support Senate Bill 5356. It aligns with the Workgroup's recommendations and would create workable requirements for fairness, transparency, and accountability in the use of automated decision systems. As recommended in the Workgroup report, the bill requires the creation of a prioritization tool that would enable agencies to practically allocate the resources towards examining high-risk systems first, such as predictive policing tools and benefits distribution algorithms. Furthermore, this bill also aligns with current global trends. In the past few years, the European Union and countries such as Canada and New Zealand have looked for ways to ensure algorithmic accountability in government decision-making, often extending beyond what this bill proposes, requiring, for example, source code transparency, the implementation of risk management systems, and the development of frameworks for determining whether certain uses of ADS should be prohibited. Senate Bill 5356 strikes an appropriate balance. While the minimum standards and procedures set forth in sections 4 and 5 are urgent and on point, they will not create an unmanageable burden for government agencies. As an academic with expertise on the risks of automated decision systems, I urge you to vote in favor of Senate Bill 5356. Washington has an opportunity to be a leader in ensuring that government use and automated decision systems does not cause discrimination and other types of harm. And this bill would be a first of its kind in the country. Thank you.
Thank you so much, Maria. Any questions from members of the committee for the panel? Seeing none, thank you so much for coming in today. We'll bring up the next group. Ann Paxton, Maya Morales, and Cindy Honhus. Apologies if I said your name wrong. Oh, and then Ann, I think you already went, so never mind. Is Maya on the testimony? Or Cindy?
I am, sorry, I was just put back in.
Oh, no worries, perfect. Go ahead and get started whenever you're ready.
Great. Good morning, Chair and members of the committee. My name is Maya Morales, and I'm founder of Washington People's Privacy. I appreciate the opportunity to speak with you all this morning about automated decision systems. I want to just start by thanking Senator Hasegawa for his insight and his care for people in our state in continuing to ask for movement on review of automated decision systems used by the state. I think others have raised in really well-spoken ways a lot of the issues and the harms that can occur if we don't sort of vet these systems and understand what they do. And so I kind of want to take a slightly different tack here. The way that I see this bill is that it actually comes from a place of love for Washington residents. It centers the human beings of Washington. And so I want to share something that I learned over a decade ago in my master's program in teaching, which was a piece of the experiential learning cycle that had people ask the question, does this help or does this hinder? And I think that's basically what this bill does. It asks us to look at systems and try to understand, are these actually helpful to human beings in our state, or are they maybe hindering and creating inequities that we don't really want humans to experience here? So I think that part of the thing that I see as an opportunity in this bill is for us to come together as Washington residents and have an opportunity to understand the systems our state is using and really look at them as a way to understand equitable relationships between systems and humans. And so I really hope that lawmakers will begin to support this and understand this is so key to everyone in Washington state having an equitable and just future. Thank you so much for your time this morning.
Thank you so much. And then Cindy.
Yeah. Hi, I'm from Washington Patients and Intractable Pain. We advocate for people with complex diseases or injuries that cause pain, directly affecting their quality of life. Since September, we've been working with the Department of Health to stop implementation of an automated decision system called NarxCare. NarxCare scores all patients receiving an opioid, no matter what circumstance, low, medium, or high risk. This directly influences a provider's decision to prescribe or not. That information in the algorithm is gleaned from data inside and outside of our prescription monitoring system. The algorithm considers the entire electronic health record, past trauma, location data, claims data, criminal data, and more. We just don't know because the algorithm is proprietary. NarxCare targets disabled people in poor health who have moderate to high pain that interferes with their lives. 17% of high scores are false amongst disabled patients, meaning that 72,000 patients will be denied care upon implementation of NarxCare. This doesn't include the high scores due to lack of clinical context related to chronic disease care. 20% of high scores were from cancer patients. It also targets minorities and women due to historical bias and data set that it examines. Yet our Department of Health would have gone forward with implementation and still can. They have no process to approve or disapprove the algorithm, no research. They are not required to ask or show proof that the algorithm works. There is no expert or stakeholder input, no public meetings or testimony, zero accountability. There will be no consequences for damages to patients, no follow-up on patient outcomes. We're the only ones standing between the state and patients to protect them from disastrous destabilization of care. A decision with such far-reaching consequences cannot be made in secret. There is an immediate emergency need for guidelines for automated decision-making tools, including support tools such as NarxCare with a high potential for bias and patient harm. We need to implement boundaries, checks and balances, accountability, transparency to protect patients from the poor health outcomes. We strongly support SB 5356. Thank you.
Thank you so much. Any questions from members of the committee for the panel? Seeing none, we'll go to our last panel, Kelly Busey and then Jonathan Pincus.
Good morning, Mr. Chair and members of the committee. My name is Kelly Busey. I'm here this morning to testify as other on behalf of the Washington Association of Sheriffs and Police Chiefs. In short, like the senator before me asked, we're trying to gain clarity on SB 5356 and what exactly is or is not included in the scope of an automated decision system to make sure that some tools used by law enforcement are not unintentionally caught up in the intent of the bill. For instance, we wonder if things like automated license plate readers designed to search for stolen cars is included, or polygraph machines that we use in law enforcement hiring. Common processes such as used in our crime labs, such as DNA analysis or firearms analysis or fingerprint comparison searches are included. There are also systems that generate photographic lineups that are used to include a picture of a suspect with other similarly looking individuals to see if a victim or witness can independently identify them. And also, but not finally, crime analysis tools that compile where crimes have taken place or are likely to occur. And we recognize and fully support any effort to eliminate bias or discrimination in these systems, but need to ensure that the use of technology remains available in an achievable manner to help keep our communities safe. So we would invite more conversation with the bill sponsor to fully understand the scope of the systems being described as part of this process. Thank you.
Thank you so much. And then Jonathan.
Chairman, Ranking Member McEwen, members of the committee, I'm John Pincus from Bellevue, a technologist and entrepreneur, founder of the Nexus of Privacy. In 2021, I was a member of the Washington State ADS work group. Thank you very much for holding this hearing, and thank you for the opportunity to address you today. I strongly support SB 5356. As you've heard, the systems that run our state government often have biases that reinforce and magnify discrimination. And it's not surprising. Most systems in use at state agencies today were designed and implemented before current best practices were developed. The Department of Correction Systems the work group looked at hadn't even implemented simple bias testing. The longer we wait to start regulating these ADS, the more Washingtonians are harmed. And the longer we wait, the greater the liabilities to the state and the more expensive it will be to clean it up. The partial fiscal note for the bill's predecessor in 2021 estimated the cost over the first 2 years at $8.5 million. Now the estimated price tag has risen to $22 million, and that's just the first 2 years. How much higher will the estimates be if we wait till next year? The bill as written is a good first step. It sensibly starts with the highest priority systems. Responding to Senator Wellman's very valid point here, we don't want to waste our time looking through every single spreadsheet on the planet. The bill doesn't ask for that. It gives agencies the flexibility to priority. It includes auditing and transparency requirements, and it introduces procurement requirements for new systems to keep the situation from getting worse. That said, the bill as written is certainly not the only possible first step. If there's time to develop a substitute and get agreement, it could make more sense to advance that. Either way, I strongly second Senator Hasegawa's point and urge you to advance something. It's critical to continue these discussions in order to identify an achievable and fiscally responsible first step. Thank you for the opportunity to provide testimony today, and I'll follow up with expanded written testimony, and I welcome any questions.
Perfect. Thank you so much, Jonathan. And actually, going back, Cindy, do you happen to still be there? I don't think you introduced yourself for the record. If you are still there, would you mind just repeating your name and then your organization, if any, for the record?
Cindy Hohenhaus, Washington Patients and Intractable Pain.
Perfect. Thank you so much. Any questions from members of the committee for the panel? Seeing none, thank you so much, and thank you so much, Senator Hasegawa, for staying as well. We'll go ahead and close testimony for this bill, and then we'll move on to 5718.